North Carolina bill could make repeat nonsexual nudity a felony. HB 308 would require sex offender registration after a second indecent exposure conviction, even though the state's basic exposure law does not require sexual or lewd intent. A North Carolina criminal law bill awaiting action in a conference committee would make a repeat indecent exposure offense after a prior conviction a felony and require the person to register as a sex offender, raising concerns for naturists because the state's underlying exposure law does not require sexual intent. House Bill 308, a broad package of criminal law changes, is currently before a House-Senate Conference Committee after the House declined to accept changes made by the Senate. Senate conferees were appointed August 6th, and no further action was listed by the North Carolina General Assembly as of August 21st. The fifth and current edition of the bill would create an offense called habitual indecent exposure. Under the proposal, someone convicted of one of several indecent exposure offenses after a previous qualifying conviction would be guilty of a Class F felony. The court would also be required to order the person to register as a sex offender. The provision is notable for naturists because North Carolina's existing basic indecent exposure law reaches beyond sexually motivated behavior. Under GS 14-190.9a, a person commits a Class II misdemeanor by willfully exposing their private parts in a public place in the presence of another person. The statute does not require prosecutors to prove that the exposure was lewd, intended to cause offense, or motivated by sexual gratification. The distinction is clear elsewhere in the same statute. A separate felony provision involving exposure in the presence of a minor specifically requires that the act be committed for the purpose of arousing or gratifying sexual desire. Another provision covering certain exposure on or near another person's private property contains the same requirement. The basic public exposure offense does not. North Carolina courts have also interpreted parts of the law broadly. In State v. King, the state Supreme Court rejected an argument that indecent exposure required an unwilling audience. The case involved nude performances before patrons who had chosen to attend. Courts have likewise held that a public place is not necessarily limited to publicly owned property. North Carolina case law has focused on the way a location is used and its accessibility to others. That makes the application of the statute to particular private clubs, events, or other naturist settings dependent on the circumstances. HB 308 would not expand the conduct covered by the basic indecent exposure statute. It would sharply increase the consequences of a second conviction. Under the bill's current language, a person previously convicted of basic indecent exposure could later face a Class F felony and sex offender registration for another violation of the same law. Nothing in the habitual offender provision limits that enhancement to sexually motivated exposure. The bill would also retain existing language allowing prosecution of owners, managers, lessees, promoters, and others who knowingly permit premises under their control to be used for prohibited exposure. If enacted in its current form, the new provisions would apply to offenses committed on or after December 1, 2026. Because HB 308 remains in conference committee, its language can still change before reaching a final vote. For naturists, the issue is not that the bill creates a new prohibition on non-sexual nudity. It is that North Carolina already has an indecent exposure law that does not require lewd intent, and HB 308 could attach felony penalties and sex offender registration to a repeat violation of that law.
We hope you're enjoying Planet Nude. If so, please consider a paid subscription. Your membership comes with exclusive content and supports our work. Subscribe at www.planetnude.co.